It's still wild to think about. 8 months. That's all it took. 8 months from the moment I walked out of Vance and Stone, carrying a single banker's box, to the day that entire, venerable Dallas institution was effectively gone. Not just dissolved, but absorbed, its legacy erased, all because a trust fund kid wanted to give his girlfriend my job. And the thing is, I knew it would happen. Not the exact timeline, or every little piece of the puzzle, but that day, sitting in my now-too-quiet home office, watching my dog Murphy look at me like I'd finally lost my mind, I realized one crucial thing: I hadn't just been fired. They had unknowingly handed me the match to their own funeral pyre. The shock was still there, a dull ache behind my eyes, but it was quickly giving way to something colder, sharper. This wasn't just anger. This was focus. Because you spend years, 3 years in my case, grinding 70-hour weeks at a place like Vance and Stone in Dallas. 3 years pouring your soul into building relationships, never calling in sick, believing that loyalty and hard work actually meant something. And then, the very morning I was supposed to close the biggest deal of my career, the Titan Industries acquisition, worth a cool $800,000 in billings, I got canned. Fired. By a guy who'd never even passed the bar exam. His name was Dylan. He was 29. The firm's official bio said he'd pursued entrepreneurial opportunities before joining the family business. What that really meant was he dropped out of Stanford, failed the bar twice, and his father, Robert Vance, who'd had his name on the building since 1986, created a position for him, executive director. A job that didn't require a law license. They'd brought him on 7 weeks earlier after what they called an extensive national search, which I imagine consisted of Robert yelling Dylan. Get in here. That Monday started like any other. Coffee at 6:30, at my desk by 7, running through those Titan documents for the 20th time. My direct boss was stuck in depositions, so the email pinged at 9:47 from Dylan himself. Please come to my office immediately. I saved my work. His office, that is. It used to be a senior partner's, a man with 30 years of trial experience who'd argued before the Texas Supreme Court. 3 days after Dylan arrived, that partner was relegated to a windowless room near the break room. We all watched him clear out his diplomas, not saying a word, while Dylan's decorator measured for new curtains. Now, instead of law books, there was a neon sign that blared, "Move fast and break things." Because nothing says serious legal practice like Silicon Valley cosplay, right? He didn't even look up when I walked in. Just scrolled on his phone, designer sneakers propped on his father's imported Italian desk. It's Ethan, I said, before he could call me the wrong name again. We've met 6 times. I closed the Hansen deal last month. You signed the congratulations card. His eye twitched. A tiny tell. Good. I'd already gotten under his skin. Whatever, he drawled. Look, I'm not going to waste time. He slid a packet across the desk. No build-up, no explanation. Just a stack of papers with yellow signature tabs, like I was closing on a used Honda. Today's your last day. You're firing me the week before Titan closes? I asked, completely baffled. Who will handle the transition? Chloe will, he said. Chloe. His girlfriend. The paralegal who'd started 5 weeks ago and couldn't format a memo without calling for help 3 times. She'd worked at a nail salon before this. Nothing wrong with nail salons, but there's a serious learning curve from acrylics to acquisition agreements. I'd caught her using ChatGPT to draft a client update last week. It included 3 hallucinated case citations that didn't exist, and one from an entirely different state's jurisdiction. Chloe doesn't have a law license, I pointed out, my voice flat. She legally can't handle this. His smile was all teeth, zero warmth. A rich kid smile, the kind you pick up when you've never faced a consequence in your life. That's no longer your concern. 3 years. 3 years of skipped vacations, working through food poisoning, building relationships with 41 corporate clients who called my personal cell at 2 a.m. when deals fell apart. 3 years of holding that place together while the partners took long lunches and Robert Vance collected checks from a beach house in Corpus Christi. And this trust fund accident was handing it all to his girlfriend because she looked good in a pencil skirt. What's the actual reason? I pushed. Not the synergy, the real reason. He leaned back, pressing his fingertips together like a villain in a children's movie, a TED Talk pose he probably practiced in the mirror. You're a dinosaur, Ethan. Old school. The firm is evolving, and you don't fit the culture I'm building. We need fresh perspectives. Innovative thinking. People who understand disruption. The culture where your girlfriend replaces a licensed attorney? Watch yourself. His voice went cold, a quick flash of something real and ugly under all that startup bro energy. I could make this severance package disappear with one phone call. My father built this firm. I can rebuild it however I want. Frankly, you're lucky I'm giving you anything at all. I picked up the packet. 3 months severance for signing away my right to talk, compete, or exist in any way that might embarrass the firm. It was an enhanced severance in exchange for a broader release and tighter non-compete than what I'd signed on day one. But Texas courts had been gutting those overreaching non-competes for years. Getting fired so the boss's son could give your job to his unqualified girlfriend? That sounded like the textbook definition of bad faith termination. Some judge was going to have a field day with this. 1 hour, Dylan repeated, reaching for his phone. I slid the packet back, not signing anything new. Have counsel send it to mine. I walked out, still bound by my original agreement's confidentiality and non-solicit clauses, but not giving him anything extra. Security, 2 guys I'd never seen before, showed up in under 3 minutes. No small talk. No apology. They just stood there while I packed. The whole floor suddenly became obsessed with urgent emails. One junior I'd mentored mouthed sorry and went back to typing. Word was already out. I was toxic. An hour to pack up 3 years. I grabbed my personal laptop, the one that kept the place running when their servers crashed. My phone, with client numbers and my own contacts. My contract law books, full of my notes. And the photo of Murphy on my desk. What they couldn't box up was everything that actually mattered, the relationships, the trust, the 2 a.m. phone calls. 3 years of knowing which client needed reassurance and which needed a kick in the ass. None of that fit in a banker's box. I walked past the commissioned portraits of 3 generations of firm founders, Frederick, who'd represented Dallas oil barons when Texas was still wild. James, the builder, who'd turned a 3-person shop into a regional powerhouse. And somewhere in the back office, posting Instagram stories about the grind, was Dylan, the destroyer. But as I pushed through those glass doors for the last time, I wasn't thinking about what I'd lost. I was thinking about what they'd forgotten I still had. The house was too quiet for a Monday. Murphy kept looking at me, head tilted, confused why I was home. I should have been in the Titan meeting, celebrating another closed deal. Instead, I was unemployed, and my dog thought I'd lost my mind. The shock was wearing off though, replaced by that cold focus. You spend years telling yourself loyalty matters, that hard work gets rewarded, that the system is fair. Then some trust fund kid fires you to give your job to his girlfriend, and you realize, oh, that's how it works. Good to know. I made a pot of coffee at 2:30 p.m. Sleep was optional now. I started figuring out what I actually owned versus what Vance and Stone thought they controlled. Turns out, a lot. Templates I'd built on my own laptop. 41 executives who texted me photos of their kids' graduations and called my personal cell. And 3 years of knowledge that couldn't be handed off, like the hidden arbitration clause I'd found in Titan's vendor agreements, which could have cost them millions, quietly fixed across 17 contracts before anyone even knew there was a problem. My phone buzzed. A text from a junior associate I'd mentored, the one who'd avoided eye contact. Heard what happened. Can't believe it. Dylan says Chloe is taking over your files. She's supposed to be the client-facing point person now, except she just asked the paralegal pool what consideration means in contract law. Like, the basic concept. Associates are scrambling, but nobody's supervising them. We're so screwed. I didn't respond. My employment agreement was vague about personal communications, and I wasn't taking chances yet. But the text confirmed my suspicion. Panic was already setting in over there. By 4:30, I'd turned my dining room into command central. 3 years of knowledge spread across the table. Not client files, those legally belonged to the firm, but my personal notes, my systems, my frameworks, the infrastructure that had made me valuable in the first place, the stuff they didn't even know existed. I set up a new email, CM Consulting. Not a competing firm. Just a professional presence. Updated my LinkedIn to independent legal consultant. No mention of the old firm, no violation. Then I waited. The first text came at 5:43. Natalie from Titan. Ethan, the new lawyer just asked me what force majeure means. In the middle of our deal review. Please tell me this is some kind of joke. I stared at the message. Technically, responding about the Titan deal would violate my confidentiality obligations. But expressing sympathy for a friend's frustration? That was just being a decent person. No longer with Vance and Stone as of today. Hope everything goes smoothly with your deal. Her response was instant. What? Call me now. Bound by certain agreements. Can't discuss specifics. You should probably get independent counsel before making any decisions. Can you discuss anything over coffee? As friends? I smiled for the first time all day. As friends, always. By 8 that evening, I'd gotten similar messages from 4 other clients. Word spreads fast in Dallas corporate circles. Everyone knows everyone. Everyone talks. I didn't reach out to anyone. Didn't send a single blast email. Didn't work from any client list. Didn't solicit a damn thing. They found me. Each time. I kept it clean. Confirmed I was gone. Noted I was restricted. Suggested they get independent advice. Made it clear I existed. I was out here. And I wasn't the one who'd abandoned them. Then my mom called. I should have let it go to voicemail. I knew better. But 3 years of corporate law had dulled my survival instincts when it came to family drama. Ethan, honey, she chirped. I just got off the phone with Dylan. My stomach dropped. You did what? Called the main line. Told them I was your mother and demanded to speak to whoever fired my son. Gave that little snot a piece of my mind. Told him his father should be ashamed. That I know people at the Chronicle. That what he did to you was probably illegal. Every single sentence was ammunition for a harassment claim. Evidence I was orchestrating a campaign against the firm through third parties. Proof I couldn't be trusted to honor my agreements. Do not contact them again. Ever. I'm just trying to help, sweetheart. You always did let people walk all over you. Mom, listen to me very carefully. You are not helping. You are handing them a weapon. Do not call the firm. Do not call the Chronicle. Do not post anything on Facebook. Do not talk to anyone about this. I will handle it. Are we clear? Silence. Are we clear? Fine, her voice was small, hurt. I didn't have time for hurt. I'll call you when this is over. I hung up. Then I drafted an email to the firm's outside counsel. No apology, no explanation, no emotion, just documentation. Third-party communication. I did not authorize or direct any communication from any third party to your client or any representative of your client. I have instructed the individual in question not to initiate further contact. Please direct any additional correspondence regarding this matter to me directly or to my counsel. Sent. Then saved a PDF and forwarded it to my own counsel. The email documented 3 things. I didn't direct the contact. I stopped it. And I wasn't playing games. No groveling, no panic, just process. Dylan thought he'd removed a replaceable part from his machine. What he didn't get was that modern legal practice isn't about marble lobbies and family names on letterhead. It's about the 3 a.m. phone calls, the weekend emergencies, the trusted voice who actually knew what force majeure meant and could explain it without checking Google first. They had the building. I had everything else. For days into unemployment, I sat across from Arthur in a conference room that smelled like money and old leather. His firm was 8 blocks from my old shop, close enough to share lunch spots, far enough to maintain professional distance. I'd reached out through a mutual contact, someone who'd worked at both firms and owed me a favor from a deal gone sideways 3 years back. I framed the meeting carefully, not job hunting. Just 2 legal professionals discussing the market over coffee. The fact that we moved from a coffee shop to Arthur's office by the second hour was his idea. Arthur was 68. He'd built his firm from scratch, starting in a 1-room office in Uptown. 22 lawyers, compared to Vance and Stone's 140. But they'd survived 35 years by being smart instead of big, by specializing in corporate work that required actual expertise instead of just big firm letterhead. The kind of firm that survived recessions and industry shifts while flashier operations collapsed under their own weight. Independent work, he said, studying me over reading glasses. With your client relationships. I maintain personal friendships with Dallas executives, I clarified. Those friendships persist regardless of my employment status. Dylan called me yesterday. Arthur poured water from a crystal pitcher. His hands were steady. Warned me about a former employee who might violate his non-compete. Suggested any firm helping you would face significant litigation. His words said, "My father's firm has never lost a lawsuit." My stomach tightened. Arthur continued, "I told him his father's firm has never faced a lawyer who knows where all the bodies are buried." He set down his glass. Also told him to take his threats elsewhere, but I used more professional language. The sentiment was clear. For the first time in days, I felt something like hope. The arrangement we worked out took 3 hours to nail down. Independent consultant, not employee. That kept the non-compete in a gray zone. I'd work my own matters, build my own practice. Arthur would provide infrastructure, malpractice coverage, and most importantly, legal protection if the old firm got nasty. They will get nasty, Arthur said. Robert Vance doesn't lose gracefully. He's been the biggest fish in Dallas legal for 30 years. His ego can't handle this. And from what I hear, his son is worse. All the arrogance with none of the accomplishments to back it up. I'm counting on it. My phone buzzed before I could explain. 3 texts in rapid succession. Natalie, deal fell through. Chloe missed critical deadline. Board is furious. A CFO I'd worked with for years, need to talk. Urgent contract issue. Call me. And from a number I didn't recognize, Mr. Ethan, I'm general counsel at Foster Industries. Natalie suggested I reach out regarding representation. Are you taking new clients? Foster Industries. $12 billion in annual revenue, 3,000 employees. Never a client of Vance and Stone. They'd been with an Austin firm for years. I looked up at Arthur. I accept your terms. When do I start? How about right now, he grinned. Looks like you've got some calls to make. The first real domino fell at 3:22 a.m. on a Tuesday, 2 weeks after I'd set up at Arthur's firm. My phone lit up. the general counsel at a holdings group I'd worked with for years. Their current lawyers, my old firm, had just received a compliance notice from the state. Data privacy violations. Potential six-figure fine. Their lawyers said it was nothing. Don't worry about it. She was worried. I found the issue in under 5 minutes. Outdated retention policies. Exactly the kind of thing I'd flagged in a firm-wide memo 8 months ago. A memo that had been marked reviewed but never acted on. A memo Dylan had probably used as a coaster for his overpriced espresso. Deadline for remediation was Thursday. 2 days to fix something that should have been caught months ago. The next morning, her company officially retained Arthur's firm. Their first request, all documentation from my old firm regarding previous compliance work. The files they sent over were a disaster. 2019 templates in a 2024 regulatory environment. Zero evidence of the audit I'd recommended. Arthur walked into my temporary office around 10, grinning like a kid on Christmas morning. Their paralegal just called. Wanted to know if we have a template thingy for data privacy compliance. Direct quote. Chloe. The very same. Also asked if we could send over the checklist thing Ethan used to use. Apparently, she's heard you had systems. Chloe was the point person for 41 corporate accounts by herself. 40 now. And from what I heard, she was routing everything to junior associates who were working around the clock with zero supervision. The partners were absent. The associates were drowning. And Chloe was the only one talking to clients. The GC I just spoke with formally terminated Vance and Stone's representation. Conflict of interest, she said. Can't have the firm that missed the violation defending against it. 1 down, 40 to go. But here's the thing about dominoes. They don't fall in nice straight lines. Not in real life. Real life is messy. Full of setbacks and complications. The remediation took 72 hours of around-the-clock work. We filed the response with 8 hours to spare. Avoided a potential $600,000 fine. But then another client's urgent contract issue turned out to be a complete nightmare that required pulling in 2 additional specialists and 3 days of barely sleeping. One of my scheduled consultations fell through when the client got cold feet about switching firms mid-deal. Their CFO was golfing buddies with Robert Vance and didn't want to rock the boat. And my former mentee at Vance and Stone texted me that they were telling clients I'd stolen proprietary information, that I'd copied confidential files, that I was dangerous and unstable. The whisper campaign had started. It got worse. One promising lead from a medical device company went completely sideways when their general counsel mentioned he'd heard concerning things about my departure. Wouldn't say what? Wouldn't say from whom. Just that vague corporate speak that means someone's been poisoning the well. I lost 3 potential clients that week. Each one citing due diligence concerns or timing issues. Corporate 4-year toxic. So I went robotic. Gym. Office. Sleep. Every rumor screenshotted. Every weird outreach logged. If they wanted a mess, they were getting paperwork. Arthur pulled me aside after the 3rd rejection. They are playing dirty. Dirtier than I expected. I know. You ready for what comes next? He handed me a legal filing. A cease and desist letter addressed to Arthur's firm from Vance and Stone's outside counsel, claiming tortious interference with business relationships, demanding I be terminated immediately or face litigation. The shot across the bow had arrived. 3 weeks in, and things weren't going according to plan. Sure, I had 7 clients who'd moved to Arthur's firm. Real companies, real revenue. But the old firm was fighting back harder than I'd expected. Robert Vance had come out of semi-retirement, cutting short his Corpus Christi beach house exile to personally call every major client, reassuring them, promising them, lying to them about how stable the firm was, how the transition was going smoothly, how Chloe was exceeding expectations. Dylan was apparently on his best behavior, attending meetings sober, keeping his mouth shut, letting Daddy clean up his mess. Then the malpractice carrier situation exploded. Arthur called me into his office one Thursday afternoon. He looked like he'd aged 5 years overnight. Vance & Stone's carrier had gotten wind of the compliance mess. Worse, one of the departing client's general counsel had sent a formal reserving rights letter regarding potential claims. In insurance terms, that's a grenade with the pin pulled. The carrier launched an emergency review, started demanding documentation, asking uncomfortable questions about every file Chloe had touched. They jacked Vance & Stone's premiums 40% and demanded a formal remediation plan. How does this affect us? I asked. Our renewal is in 4 months. Carriers are going to start asking questions about everyone's supervision practices. Arthur poured 2 glasses of water. Your revenge might blow back on the firm protecting you. The winning part looked clean on paper. The day-to-day was me eating cold takeout over my keyboard at midnight, spending half my time putting out rumors instead of doing legal work. Then it got worse. A bar investigator showed up 2 days later. Turns out a CEO whose family had been friends with Robert Vance for 40 years had filed a grievance against me personally. Abandoning ongoing matters. Leaving clients in the lurch. Damaging client interests through negligent departure. Garbage complaint. I had documentation showing I'd been terminated, not that I'd abandoned anything, but complaints have to be investigated regardless. 2 hours of questions I couldn't fully answer without violating confidentiality. The investigator was relentlessly, exhaustingly thorough. Professionally neutral, never hostile, never friendly. Just pen on paper, steady and relentless, like watching your fate being written in real time. After she left, Arthur closed the door. That complaint has the old firm's fingerprints all over it. The CEO's father and Robert were in the same fraternity. This is coordinated. They're not just fighting to keep clients. They're fighting to destroy you personally. 3 weeks ago, I'd walked out thinking I had all the leverage. Now I was looking at a bar investigation, insurance complications, and a whisper campaign designed to make me unemployable. Dylan was an idiot, but his father wasn't. What do we do? Arthur smiled. It wasn't a nice smile. We stopped playing defense. The bar complaint ended up being the best thing that could have happened to me. See, here's what Robert Vance didn't anticipate. When you file a grievance against someone, you create a paper trail. You open a door that swings both ways. And when that paper trail gets examined by investigators who actually know what they're looking for, it reveals a lot more than just the target's supposed misconduct. Our response to the bar included a detailed timeline of my termination, the lack of transition period, the replacement of a licensed attorney with an unlicensed paralegal as the client-facing point person. The fact that Chloe had no legal training and was coordinating matters that required proper attorney supervision, routing work to unsupervised junior associates, communicating directly with clients on legal strategy, the missed deadlines that followed, the compliance failures, everything documented, everything time-stamped. The bar investigator started asking questions not about me, but about Vance & Stone's supervision practices. About who was actually doing legal work over there and what their qualifications were. Suddenly, the complaint wasn't about me abandoning clients. It was about whether they had engaged in unauthorized practice of law by allowing Chloe to coordinate matters without proper oversight, and whether the firm's supervision failures had created the very client harm they were blaming on me. The boomerang had started its arc. Meanwhile, I'd been quietly building something else. Remember those regulatory alerts I'd flagged back when I was at Vance & Stone? The ones in the firm-wide memos nobody read? I'd kept copies of my own analysis. General commentary on regulatory changes affecting Texas businesses. Public information that anyone could access if they knew where to look. Nothing confidential, nothing client-specific, just my professional observations on developments in the law. I started publishing a LinkedIn newsletter, Regulatory Updates for Texas Businesses. Public service content about compliance changes and common gaps. My name on every post. Completely transparent. Completely devastating if your current law firm hadn't been keeping up with changes I was explaining to anyone who'd read. The calls started coming faster after that. Our board has concerns about regulatory exposure. We need a second opinion on our compliance posture. Someone sent us information about data privacy requirements. We'd like to discuss our current representation. But some leads still went mysteriously cold. Same pattern, initial enthusiasm, then sudden radio silence, vague emails about timing concerns. The whisper campaign wasn't just coming from Vance and Stone. Someone else was working the Dallas Assistant Network, the EAs and HR coordinators who trade information at quarterly luncheons. One raised eyebrow from someone plugged into those circles can poison a dozen leads without leaving fingerprints. Corporate people are allergic to drama. They don't need proof. They need plausible deniability for passing on a candidate. I couldn't prove who was behind it. Couldn't confront anyone without looking paranoid. But I could build a firewall. I called every client who'd moved to Arthur's firm and asked them to vouch for me. Not to strangers, but to their peers. CFO to CFO. General counsel to general counsel. Real references from people who'd actually worked with me, not lunch table rumors. If you can't name specifics, it's just gossip. And corporate people can smell that from a mile away. The client count climbed anyway. 12 by week 4, then 15, then 19. Still, for every one that jumped, 2 stayed. Because Robert Vance played golf with their CFO. Or because nobody wants to be first to leave. The ones who stayed felt like betrayal. Meanwhile, Vance and Stone's malpractice carrier kept tightening the noose. The 40% premium hike was just the opener. Now they wanted a formal remediation plan, which meant outside consultants digging through their processes. Which meant admitting their processes were broken. Clients saw auditors crawling around and started getting nervous. The bar complaint was still hanging over me, and I wasn't sleeping. Not grind-set sleep deprivation. More like my brain refusing to shut off. Then week 7 hit. A process server walked into Arthur's office with a stack of lawsuits thick enough to double as furniture. They sued me personally. Sued Arthur's firm. And sued 3 clients who'd switched, claiming tortious interference. They'd hired a notorious plaintiff-side litigation shop, the kind of firm that defends tobacco companies and chemical polluters. When you hire lawyers like that, you're not looking for justice. You're looking to bury someone in legal fees until they surrender or go bankrupt. The morning the lawsuits were filed, Natalie called. "Ethan, I just got served. They're claiming I conspired with you to destroy their firm. I'm being sued for hiring a better lawyer. I'm sorry you got dragged into this." Don't be. There's a Dallas GC roundtable. Informal group of general counsels who share notes on outside counsel. We're coordinating defense costs. Pool the risk. Share the burden. They won't back down from a handful of defendants. Good. Let them burn through their legal budget fighting a war on multiple fronts. Within a week, the defense coalition had grown to nearly 30 companies. It wasn't some dramatic alliance with a war room and matching jackets. It was a group chat, a shared retainer agreement, and a bunch of corporate people who loved paperwork more than they loved drama. Years of being overcharged by big firms. Years of feeling like they existed to fund partner bonuses. All that quiet resentment had been sitting there, waiting for a reason to move. Now they had one. They pooled resources and hired a litigation boutique that had built its entire reputation on one thing, making aggressive plaintiffs regret ever filing. The boutique's senior partner had a nickname in Dallas legal circles, the Refund. Because companies who sued his clients usually ended up paying for the privilege. And Vance and Stone's lawyers had made a critical error. To prove I'd stolen client relationships, they needed to show those relationships belonged to the firm, which meant deposing every client who'd left. 37 witnesses ready to testify they'd trusted me specifically, not the firm's letterhead. They just handed us the ammunition to destroy their own case. 2 weeks later, while I was still fielding calls from nervous clients and running on 4 hours of sleep, the bar's initial inquiry into my conduct concluded. The bar investigators' report found insufficient evidence of misconduct on my part. But it found substantial evidence that Vance and Stone had engaged in supervision failures and improper delegation. The report recommended further investigation into the firm's management structure and oversight procedure, triggering an expanded review that would dig far deeper than the original complaint ever intended. Dylan's name came up in the initial findings, but not the way you see on TV. No public wanted poster. No formal sanctions plastered on the bar website. Just preliminary observations about his role in the supervision breakdown. Observations that would be examined more thoroughly in the expanded investigation. Robert Vance had weaponized the bar against me. The bar had decided to investigate him instead. 8 months. That's how long it took for everything to fall apart completely. The bar's expanded investigation spread like a crack in a windshield. What started as an inquiry into my conduct had become a full audit of the old firm's practices over the past 2 years. Every file Chloe had touched. Every deadline that had been missed. Every client who'd suffered because a 29-year-old fail son decided innovation meant replacing expertise with loyalty to whoever was sleeping with him. The final findings were brutal. 17 instances of improper delegation to unlicensed staff. 9 missed filing deadlines with material impact on client matters. 2 cases where clients had suffered actual financial harm due to negligence. 1 had paid a late fee that wouldn't have existed if someone competent had been watching the calendar. And 1 spectacular example where Chloe had accidentally CC'd a client on an internal email discussing how to hide a mistake she'd made on their account. That client was now suing Vance and Stone directly, separate from everything else. The firm's malpractice carrier finally pulled the plug. Dropped them entirely, effective 60 days out. Finding new coverage with that kind of record at any reasonable rate? Basically impossible. The insurance spiral had become a death spiral. Robert Vance announced his retirement, for real this time. The official statement mentioned spending more time with family and pursuing other interests. Everyone in Dallas legal circles knew it meant he'd rather walk away from 40 years of building than watch his son finish destroying everything he'd created. Dylan didn't take over. The remaining partners staged what amounted to a coup. They voted to dissolve the firm name entirely and merge with an Austin firm. The merger was technically an acquisition. The remaining lawyers would become employees of the new firm. The Dallas office would survive in some form, but the old name would disappear from the letterhead for the first time since 1986. The lawsuits against me and the defense coalition quietly settled. No admission of wrongdoing on either side, that was the face-saving language. But the settlement included a requirement that Vance and Stone, now technically part of the Austin firm, pay the coalition's legal fees. Every dollar they'd spent trying to destroy me through litigation, every hour the boutique had billed defending us, they had to reimburse. The coalition's litigation counsel sent a final bill to Vance and Stone for $2.3 million. Payment due in 90 days. And then there was Dylan. The bar's investigation had focused mainly on the firm's practices as an institution. But there was a specific finding about him, that he had exercised supervisory authority over legal matters without proper licensure or oversight. Not quite practicing law without a license, but close enough that hiring committees would see it and run. The kind of finding that doesn't make headlines, but shows up in every background check, every due diligence review. Firms don't want the headache. They don't want to explain to their own insurance carriers why they hired someone whose name appears in bar investigation records next to phrases like supervision failures and improper delegation. I heard through the grapevine that he tried to get a job at the Austin firm after the merger. They declined. Tried another firm in Austin. Same result. Tried a small shop in a smaller town. They Googled him. When your name shows up anywhere near bar investigation records, even without formal public sanctions, it tends to end conversations quickly. Last I heard, he was running some kind of cryptocurrency consulting operation out of his apartment. Seemed about right. The final piece fell into place on a Tuesday in March, 8 months and 12 days after I'd walked out of Vance and Stone with that banker's box. I'd just finished a meeting with Foster Industries. They'd become one of Arthur's firm's biggest clients, and the relationship had expanded beyond anyone's expectations. Strategic planning, regulatory compliance, M&A advisory, the whole package. The kind of comprehensive representation I'd always wanted to build. Arthur had made me equity partner 3 months earlier. My own division, my own team of 6. 31 of those original 41 corporate clients had followed me. The others had stayed with the merged firm or scattered to other shops. But 31 was more than enough to build something real. I was packing up my briefcase when my assistant knocked. "Ethan, there's someone here to see you." "He doesn't have an appointment, but he says it's important." "Who?" "Dylan." I sat back down. Thought about it for exactly 3 seconds. "Send him in." He looked like hell. Designer clothes gone, replaced by something off the rack that didn't quite fit. He'd put on weight, the soft, unhealthy kind that comes from too many late nights and too little reason to get out of bed. His eyes had that hollow look I'd seen in clients going through bankruptcy. Funny thing was, I didn't feel anything. No satisfaction. No sense of victory. Just a tired recognition that this was always how it was going to end. He stood in my doorway, like he wasn't sure he was allowed to enter. "Sit down, Dylan." He did, in the low chair across from my desk. The same power play setup he'd used on me 8 months ago. He didn't seem to notice the irony. For a long moment, neither of us spoke. Traffic outside, the hum of the building's HVAC. Somewhere down the hall, someone laughed at something. "I don't know why I came here." His voice was barely above a whisper. "I just needed to see it, where it all ended up." I waited. "My dad won't talk to me. Chloe left 2 months ago, took half the stuff from my apartment and blocked my number." He laughed, but there was nothing in it. Turns out she was sleeping with one of the lawyers from that litigation firm the whole time we were together. Found out at a dinner party. That was fun. "I'm not your therapist, Dylan." "I know." He rubbed his face. "I just keep thinking about that morning when I fired you. I was so sure I was making the right call. You weren't, obviously." Another hollow laugh. "You want to know the worst part?" I actually believed it. All that disruption garbage. I actually thought I was going to change the legal industry, modernize my father's Dinosaur firm. Instead, you killed it. Yeah. He met my eyes for the first time. Instead, I killed it. The silence stretched. "What do you want me to say, Dylan? That I forgive you?" "No. I don't expect that." He stood slowly, like his joints hurt. "I guess I just wanted to understand how you did it. How you took everything apart so completely." I stood too, walked around the desk until we were face to face. "I didn't take anything apart. I just stopped holding it together." I handed him one of my business cards. "Petty move, maybe, but I'm not above pettiness. You fired me because you thought the job was easy. Because you thought anyone could do what I did. Because you thought relationships were just names in a database that could be transferred like files. You found out the hard way that some things can't be handed off to your girlfriend." He stared at the card. "Ethan, equity partner. My name. My title. My new home. All the things he tried to take from me, printed on a little piece of cardstock." "For what it's worth," he said quietly. I am sorry. Not that it matters now. It doesn't. He pocketed the card and walked out without another word. Didn't look back, didn't shake my hand. Just shuffled toward the elevator like a man walking to his own funeral. I watched the doors close on whatever was left of Vance and Stone's legacy. On 7 weeks of Daddy's fail son. And 5 weeks of girlfriend-based succession planning. On innovation and disruption and moving fast and breaking things. Then I went back to my desk and got to work. If you were in my shoes, would you have done anything differently?